5 men involved in clashes between rival Kempston K-Block and Mile Road gangs in 2017 have been sent to prison for their part in the kidnap and multiple conspiracies to cause GBH with intent, including a serious stabbing and shooting. The incidents all happened within 3 weeks of one another in June 2017 as the rival gang members looked to establish themselves as leaders of their respective groups. Former leaders of the Mile Road gang had been locked up thanks to Bedfordshire Police's Operation Cruise investigation into Bedfordshire gang shootings in July 2016, but this left the power void. Sentencing the men, Judge Neil Liffman QC said gangs were all at war in June 2017 over the trade of Class A and Class B drugs. The defendants have been involved in the worst blight upon life in this country, involving the toxic combination of gang association and the use of knives and guns in the pursuit of their rivalry in the course of the drug trade. During the first incident on the 3rd of June, an off-duty police officer saw a man being assaulted near Addison Howard Park in Kempston. Police tracked a car leaving the scene. The vehicle was soon found and forcibly stopped by officers in Chantry Avenue. Safa Gabonda, 25 of Walcourt Road, Kempston, was driving the car at the time and arrested at the scene, and the assault victim was freed from the vehicle. Gabonda was convicted of conspiracy to kidnap and GBH with intent at trial. He was sentenced to a 12-year prison sentence. He will serve 9 in custody and 3 on licence. On the 17th of June, 2 Mile Road gang members sought retribution with a machete attack in Hawkin Road, Bedford. Maskims Boykoffs, 19 of Brackley Road, Bedford, and Terrell Romain, 22 of Lewis Close, Bedford, were captured on CCTV heading towards the area just before 8 PM and then leaving shortly afterwards. Judge Liffman said the teenage victim of this attack virtually had his arm severed. The victim was able to walk a short way with his friends before being treated by paramedics near the junction of London Road and Elstow Road. The weapon used in the attack was recovered with the victim. Mr. Romain and Mr. Boykoffs were found guilty of violent disorder, wounding with intent to cause GBH, and possession of a bladed article at a trial in January. Mr. Romain was sentenced to 18 years in prison, while Mr. Boykoffs was sentenced to 14 years, both for wounding with intent. Both also received sentences of 4 years for violent disorder and 12 months for possession of a bladed article to run concurrently. Mr. Romain also received 3 separate sentences of 4, 4 and 2 years for drug supply offences, which will also run concurrently. 2 days after the stabbing on the night of the 19th of June, the Kempston Block gang carried out a drive-by shooting of a Mile Road gang associate. The gang shot from a 12-bore shotgun at a home in Miller Road. The shots were so powerful they went all the way through to the room at the back of the property. 2 men suffered serious but not life-threatening injuries, and the property was significantly damaged inside and out. The car used in the shooting was later abandoned in Miller Road, and when searched contained a lump hammer, knife sheath and shotgun cartridges. Fingerprint analysis linked Antonio Zhu, 22 of Warwick Avenue, Bedford, and Vincent Kingswell Shaw, 23 of Foster Road, Kempston, to the vehicle. Sentencing the pair, Judge Liffman said it was merely a happenstance that the intended targets or anyone else on the residential street had not been killed, but added that Mr. Zhu and Mr. Kingswell Shaw were entirely indifferent to that fact. Mr. Zhu, who was considered a leading light in the Kempston Block gang, received 2 19-year sentences for conspiracy to commit GBH with intent and possession of a shotgun with intent to endanger life. These sentences will be served concurrently. Mr. Kingswell Shaw was sentenced to 16 years for both offences, which will also be served concurrently. Detective Inspector Janine Graham, who led the investigation, this violence sprung up from rival gang members looking to fill the vacuum left at the top of these gangs after the previous leaders were arrested and taken off the streets. This sort of mindless violence has no place in our county. Thankfully, incidences of this severity and violence are rare, and these proceedings show the way in which those responsible will be pursued and punished. These are major sentences befitting the seriousness of the crimes that have been committed. Anyone involved in drug gangs or who could be enticed into that world should be under no doubt. You are putting your safety and even your own life at risk, while we will do everything in our power to investigate these gangs and bring them to justice. Tackling gangs and serious youth violence in Bedfordshire is one of our top priorities, and with our new bosun team dedicated to tackling gun and gang crime in Bedford, these gangs will find themselves relentlessly pursued by the law law enforcement. Senior Crown Prosecutor Charles White from the CPS added, "These two gangs routinely carried knives and guns on the streets of Bedford, resorting to violence to warn off their rivals. Despite a wall of silence from the gang members' victims, we were able to present a range of evidence to the jury, including witnesses, statements, phone data, forensic evidence, and CCTV footage, clearly placed individual gang members at the different incidences. Criminal activity and violence of this nature has no place on our streets, and we will continue to work with the police to catch, prosecute, and bring those people who engage in this activity to justice." In the same proceedings, Daniel Brownlee, 21, of Piercy Road, Bedford, received a 2-year prison sentence, suspended for 2 years, for being concerned in the supply of cannabis. Dreyfus Mussington, 23, of Barford Avenue, Bedford, received a 1-year sentence, suspended for 2 years, for a similar offence. Gang members Maxims Boykovs and Terrell Romain were refused permission to appeal against their sentences for attacking a rival with the machete. The pair from Bedford were locked up for 14 and 18 years for their parts in a street brawl that occurred as part of a turf war. Mrs. Justice McGowan, sitting in the Court of Appeal with Lord Justice Fulford and Mr. Justice Goose, gave judgment at the Royal Courts of Justice in central London.
All rise.
Yes, Mr. Singh, and thank you for your patience.
I'm obliged, my lords, my lady. I am for the applicant Boykovs only, which I know you understand. And the first application, as it were, is for leave to extend the time for the application to renew.
Well, take all your submissions in one, as it were.
Thank you.
So address us on all matters, and we'll consider your application for time.
I'm very much obliged.
As part of a general judgment at the end.
I'm obliged. So the applicant applies for an extension of time in which to renew his application for leave to appeal against sentence and a representation order. Dealing with the extension of time, first of all, on the digital case system, your lords and your ladyship will find at number 4 under the Court of Appeal Criminal Division appeal document, so it's number 4, pages 25 and 26, the letter from the solicitors which accompanied the form wishing to renew the application before the full court. In relation to that matter, it sets out a history in which I hope when the court reads the documentation accepts that no fault can be laid at the applicant's door. And when I say that, the history as I work it out is as follows. The decision of the single judge was dated the 15th of July 2019. That was sent to the solicitors by letter dated the 22nd of July 2019. Unfortunately, the copy which should have gone to the applicant went to Her Majesty's Prison Wandsworth. He had in fact been moved to the Young Offenders Institute, ISIS. By my calculations, if you work it out from the date of the single judge's decision, 15th of July, the 14-day would have expired on the 29th of July. If one works it out from the 22nd of July, it would have expired on the 5th of August. As is set out in the letter, the solicitor who had conduct with the case arranged for an interview with the applicant on the 13th of August upon her return from annual leave, only to find out that the applicant had never received the decision. because it'd been sent to the wrong establishment and hadn't been forwarded to him. Following that meeting, the solicitor sent the paperwork to the applicant at the right prison, who then sought a conference with me, which took place on the 30th of August. Following that, I received instructions to continue with the application to renew the permission to appeal before the full court. As is set out, there were some issues in relation to funding, and eventually the matter was lodged on the 13th of September. And so my submission in respect of the application for extension of time is that there is no fault, hopefully, to be laid at the door of the applicant, and that the court in those circumstances should consider whether or not, because there is no fault, he should be prejudiced in relation to the application which I now seek to make in relation to the renewal.
Well, that's very clear, Mr. Singh, and thank you for taking us to the letter, which I think is the 13th of September.
That's right.
Yes.
And as I say, number 4. My Lords, my Lady, I then turn to the application, and perhaps it may be of assistance to have my advice and grounds before you. That's at number 3 on the digital case system, pages 12 to 24. For ease, for my part, I'm probably going to use my paper copy because it's easier for me to turn pages and get the right paragraph numbers than it is for me to scroll down.
Certainly.
Thank you very much. Starting then with what is conceded as correct by the learned judge who imposed the sentence at the Crown Court sitting at Harrow back on the 12th of March of this year. The matter contrary to Section 18 is clearly a Category 1 in relation to the Sentencing Council guidelines. Mm-hmm. That's conceded. But it's the reasons why that's conceded which, in my respectful submission, are important. Your Lordships and your Ladyship will be aware that the first decision is how to get to the category, and that looks at greater harm and greater or lesser culpability. In my respectful submission, the guidelines for the offence state that for a Category 1 offence, greater harm, that is, it says, injury which is serious in the context of the offence must normally be present. Mm-hmm. And I start with this point, my Lords, my Lady. For a Section 18 offence, all injuries are going to be serious. And so, if there is to be an upgrading from the starting point, which is what the learned judge said he was doing because of the serious nature of the injury, it's difficult for us advocates to work out how much more serious it has to be as an injury to go above the starting point.
This was a wounding, wasn't it? Section 18 wounding.
No, this was a grievous bodily harm, my Lord. Or it should have been on the indictment. The injury was extremely severe. It resulted in the near severing of the victim's arm.
But the harm, which, as you say, is part of the categorisation, Category 1, greater harm, serious injury, must and will normally be present.
Yes.
Greater harm goes on to deal with the injury which can include psychological harm, which
yes.
is serious in the context
Yes.
So this is more serious in the context of these sorts of offences and of this offence, and it also brings with it continuing psychological harm.
Yes.
So all of those factors would indicate an increase from starting point, wouldn't they?
I accept that, milady. The difficulty I have is how much more that increases it from the starting point of 12 years, bearing in mind that the Sentencing Council have already said that it has to be serious in the context of that particular offence. So 12 years is the starting point, the range is 9 to 16.
Yes.
This I accept as an extremely serious injury, as I've conceded in my advice and grounds. I accept that, but how much further does it take it up the 16? I accept it goes up from 12 because of the more serious nature of it, but the difficulty is how much further it takes it up.
Well, are you able to submit how much further it should go?
His Honour, when sentencing, took it right up to the 16-year mark because of the other aggravating features. And so he took it right to the very top level.
15. 15.
15?
Yeah.
The range is 16.
Yes, but he
But he
passed
took it
a
up to
sentence of 15.
Yes.
So
And he passed 14 in relation to
yeah.
this applicant
Yeah.
because of other factors.
Yeah.
But that's the first.
It nearly took off the arm, didn't it?
That's right.
Yeah.
I accept entirely it was a horrendous injury, but it's a Section 18 grievous bodily harm.
So you say we're in the ballpark of really serious injury.
Yes.
So was this
Above.
really notable injury?
It's seeking clarification as an advocate as well as making submissions that it's a difficult concept to...
More than 12 and less than 16?
Yes.
14?
Well, milady, I would make further representations because there are other factors which, in my respectful
I
submission,
understand
may bring it lower. Moving on then to the factors which have been dealt with, which relate to culpability. It's my respectful submission that looking again at the Sentencing Council's guidelines, that there was, as it were, insufficient credit given for the fact that although this is higher culpability because of the use of a weapon, there are other factors which the Sentencing Council have indicated as lower culpability, which haven't been given proper weight, if I could put it that way. And I look first of all at the issue of being a member of a gang. And in His Honour Judge Lithman's QC's sentencing remarks, he came to the conclusion that the applicant was a member of a gang, as were the other defendants who he sentenced on other matters at other times. I concede that I can't properly argue that he's not a member of a gang, and that's on the basis that my client never gave evidence. But what I can do in my respectful submission is draw the court's attention to issues which may bring a conclusion that either one, he wasn't a member of a gang, or if he was, that he was subordinate rather than a lead role. And that, in my respectful submission, is important when you look at the background features of cases. I accept the jury were never asked to make a decision as to whether these people were members of gangs or not. I accept that the judge can come to his own conclusion having heard the trial, and I accept that it is proper for the sentence to be increased if the person is a member of a gang. But the issues I would point out are these. The first is that of all the incidents that you have read about in the sentencing remarks, the applicant was only involved in one, and that was the one on the 17th of June. He was charged and indicted on another matter, which was on the same indictment, the conspiracy to cause grievous bodily harm, but he was found not guilty of that matter. So in the whole running sequence, which the learned judge has referred to in his sentencing remarks, the applicant was involved in one incident. In relation to his role as a member of a gang, which, as I say, I almost have to accept because he didn't give evidence, but I test it. I refer, my lords and my lady, to my advice at paragraphs 70 through to 73, where I set out that there was an extensive interrogation, as one would expect, of all the mobile devices which were seized from all the parties in this matter. And it's correct to say that there were no messages found relating to the applicant which talked about or referred to violence. No planning, no instigation, no retribution, no suggestion. And in my respectful submission, that might assist the court as to whether he is a lead role or a subordinate role.
Do you accept that he took the weapon to the scene and provided it to the man who used it?
On the jury's verdicts, yes, I have to. Moving on from the issue of the generality of gang membership and messages relating to violence, in respect of the actual incident on the 17th of June 2017, it's my respectful submission again that there was no evidence that this was a pre-arranged meeting between two rival gangs. There was no communication at all which was pointed to by the prosecution, which set out that this was in some way a premeditated or planned meeting. In respect of the applicant's role, I also draw attention to paragraph 72 of my advice, which sets out the evidence in relation to his role as drug dealer. He's always accepted he dealt in drugs. He was very much an individual who was at the behest of other individuals, and again that might assist the court in coming to a conclusion as to whether or not his role was one of a leading role or a subordinate.
I think your submission to the judge in the court below was that he was essentially an associate, really.
Yes.
And is that how you would put it to us today?
That is, in short form, yes, my lord.
Sorry, I interrupted.
No. That point assists in relation to the next criteria relating to the Sentencing Council, which says these are features which can show that there is lower culpability, and one of those is lack of premeditation, and I've highlighted the issues in relation.
Took the weapon.
Lack of premeditation.
He took the weapon.
Yes, that's correct, but not to an organised fight. The evidence is that these two separate lots of people had never agreed to meet in order to fight. Unfortunately, it is a sad indictment on young people that they carry knives around with them in anticipation
Of violence.
But
So
not
premeditating violence.
Well, my lady,
I'm sorry, Mr. Singh, I know, but it is quite difficult to describe somebody who is carrying a weapon like this, and we've seen a photograph of it, and we know how much damage it was capable of doing. It is quite difficult to submit, isn't it, that somebody who's carrying that weapon and provides it to somebody else in the course of a fist fight isn't premeditating violence?
Well, perhaps, if I concede that point, perhaps if I say organised, might that be a different slant? And the final point I make about the actual incident is that the sole civilian witness who could give evidence about the matter, and I've set it out again in my advice as to the words that he used, and that can be found at paragraph 91, where it seems as though the applicant was fighting with the person who was eventually injured. The other applicant was fighting with another person. And then it's the other applicant who, in the words of the witness, all of a sudden attacked the victim with the weapon and caused the injury as is set out. And so, as I say, although I accept entirely that this is a Category 1 offence, I do say that there are areas which can reduce the severity of the sentence. In respect of other wider aggravating features and mitigating features, it is, of course, correct to say that the applicant at the time of the incident, I'm going to be very careful about this, he was of good character in terms of violence. I entirely accept that after the 17th of June, when this incident occurred, he committed another offence of violence. And it may not fall on open ears for me to try and sing and dance about good character, but it is a fact, pedantic though it might be, that at the time of this incident, he was of good character. I make no more about that.
At the time of sentence, he wasn't.
Exactly.
Right.
So
I think that is dancing a bit on a pinhead.
I accept entirely, but again, I stress it because of what the Sentencing Council tell us what to say. The final matter, which perhaps is, in my respectful submission, the most difficult one, is the sentencing of a person who at the time of the incident was 17 years of age. And at the time of sentence, 19 years of age, now 20 years of age. My lords, my lady, you know the law in relation to the matter. I'm not going to rehearse it, but it's quite...
Well, hum the tune. So what's the basic submission you'd want
So
to
the
advise?
basics are that one looks at the sentence that would be passed on an individual at the time that sentencing arises, and then give a discount for the fact that the person was of a certain age at the time. And the discount is not mathematical, but ranges between, I think, half maximum and 2/3. So my point about this really goes back to the references, the accolades and the certificates which were provided as part of the mitigation. Because in my respectful submission, what that shows is that certainly pre-teen and in his early teens, this was an applicant who was studious, who was a good member of the community, who worked hard, played hard, sporting activities, and worked well within the community and with his family. There came a stage when that stopped, and he became the individual who committed extremely serious offences as a young person. Has he got the ability to change? And the answer is, I'm told, unfortunately, the Young Offenders Institute haven't sent me the information, but since his sentence date, he has accessed many courses, He's completed many courses. His mother, who is here today, says that he's reverting back to the individual that he was. He realises what he's done is wrong. He wants to be back in the community. He wants to work hard and be a member of his family. And so that shows that although it's not very often, that my submission that a leopard can change its spots is taking fruit now. And it's the hope and desire, because essentially the applicant was first in custody in November 2017, so he had just turned 18 years of age. This sentence that was imposed will effect a release, I'm told, in 2025 in October, so just before his 25th birthday. The ages of 17 to 25, as we all know, and I don't need to tell my lords or my lady, are extremely important to all individuals. By all accounts, the incident, horrific as it may be, was caught on closed circuit television. Not the actual incident, but the preamble and the afterwards, lasted a very short period of time. And that behaviour, coupled with his later conviction, has now allowed a judge to define him as dangerous, which will stay with him. In my respectful submission, in order to give hope to an individual who was 17 at the time of the commission of the offence, now 20, that his hard work will pay off. It is only right that a sentence of this magnitude be visited very carefully and is, where at all possible, reduced, so that the efforts that are being put in by the applicant whilst he's in prison or Young Offenders Institute aren't wasted when he's released at a much later date. So, my lords, my lady, that's the application for renewal of the appeal, or the permission leave to appeal. I don't know if there are any matters.
Well, that was extremely clear, Mr. Singh. Thank you very much. We'll rise for a moment and comply with the position.
Court rise.
I ask my lady, Mrs. Justice McGowan, to give the judgment to the court.
Maxims Boykoffs and Terrell Remain both seek to renew their applications for leave to appeal against sentence today. Mr. Boykoffs is represented before us this morning by Mr. Singh, to whom we are grateful for his submissions. In addition to his application to renew, he seeks an extension of time of approximately 41 days, with which we will deal in a moment. Mr. Remain renews his application on paper. The background is as follows. On the 12th of December 2018, in the Crown Court, Mr. Remain pleaded guilty to count 7, 8 and 9 on an indictment, offences of dealing in Class A and Class B drugs. On the 21st of January 2019, in the Crown Court before His Honour Judge Lithman, Queen's Counsel and a jury, both applicants were convicted of counts 1, 2 and 6 on an indictment. Count 1 was an offence of violent disorder, contrary to Section 2, subsection 1 of the Public Order Act 1986. Count 2 was an offence of wounding with intent, contrary to Section 18 of the Offences Against the Persons Act 1861. And count 6 was having a bladed article, contrary to Section 139 of the Criminal Justice Act 1988. Each applicant was sentenced primarily in respect of count 2, the wounding with intent offence. Mr. Boykoffs was sentenced to 14 years detention in a young offenders institution. Mr. Remain was sentenced to an extended sentence under Section 226A of the Criminal Justice Act 2003. That was a sentence of 18 years, made up of a custodial term of 5 years and an extension period of 3 years. Mr. Boykoff's sentence of 14 years detention was ordered to run concurrently to a term of 4 years detention on the violent disorder offence and 12 months detention on the bladed article offence. Mr. Remain's case, all the other sentences were ordered to run concurrently. They were, like Mr. Boykoff's, term of 4 years, but in his case imprisonment for the violent disorder, 1 year for the bladed article, but 4 years for the offences of supplying a controlled drug of Class A on each of 2 offences, ordered to run concurrently, and in addition, a concurrent 2-year term for an offence of supplying a controlled drug of Class B. We note in passing, although it is of little practical effect today, that the learned judge failed to impose victim surcharge orders in either case. Those orders were mandatory, but if we do not adjust the sentences today, we are precluded by Section 11.3 of the Criminal Appeal Act 1968 from imposing those victim surcharge orders, as we are precluded from in any way increasing the sentence or dealing with these men more severely. The factual background. In the summer of 2017, 2 criminal gangs were busy in Bedford. They were in competition with one another in respect of their involvement in drug dealing. A witness who knew Mr. Remain and also knew members of one of the gangs was able to provide videos of him demonstrating hostility shown by Mr. Remain to others in the other gang. It was clear from mobile phone evidence that these 2 applicants were involved together in street dealing, and that is not disputed. On the 17th of June 2017, at about 8 o'clock in the evening, the complainant in this case, a young man to whom we will refer as JB, who was 16 years of age at the time, suffered a very serious injury to his arm and wrist. That injury meant that his arm was almost hacked off by the use of a machete. The incident took place in what is described as a small residential road in the heart of one of the 2 gangs' home territories. It was clearly an incident that occurred during a clash of these 2 gangs and in which the applicants were involved. There had been fist-fighting between the victim and another young man, and it seems that members of each gang were in possession of knives or bladed weapons at the time. One, in fact, was later recovered from the victim's jacket. CCTV footage showed the 2 applicants walking together into that road. Mr. Remain had taken his shirt off and was holding a drink. Mr. Boykoffs was carrying a large rucksack, which in due course was found to house the machete which he had been carrying. Fights started by various gang members punching one another, but at some point in the incident, the machete was removed from the rucksack and was used. It was handed to Mr. Remain, who used the weapon, swinging it over his head, down onto the right forearm of the victim, and the arm, as we say, was almost severed through its full thickness. Unsurprisingly, the victim and his friend ran away. Mr. Boykoffs also ran away from the scene with the machete, which by that stage he had wrapped in Mr. Romain's shirt. It was the Crown's case that Mr. Romain had dropped the weapon, having used it, and Mr. Boykoffs recovered it and carried it away from the scene. The drugs offences, which are to some extent the background to all of this offending, occurred at least in part between these two applicants. They had been involved together in the supply of cocaine, heroin and cannabis over a period from the early part of 2017 to the spring of 2018. Mr. Boykoffs had previously been dealt with by the youth court for some of this offending. It was clear that they were together involved in the dealing in these drugs in and around the Bedford area. The dealing seems mostly to have involved Class A drugs, and there were occasions on which it was clear from the text and messages, other messages between them, that each had strayed into the other gang's territory, or other members of the other gang had strayed into theirs. In due course, the matter was listed over a period of 2 days for sentencing, and many others were sentenced at the same time. The learned judge was asked in mitigation on behalf of both young men to consider the question of imposing a determinate sentence. It was accepted, as it is accepted today, that an immediate custodial sentence was inevitable in each case. That the learned judge was asked, notwithstanding any finding of dangerousness that he might reach, nonetheless to impose determinate sentences. Each man had, in respect of them, a pre-sentence report setting out the fact that all the criteria for the finding of dangerousness was established in each of their cases. It was submitted on behalf of Mr. Boykoffs in the Crown Court that his convictions were not gang-related, that he had already by that stage spent a substantial period in custody, which, because of the sentencing in the youth court, would mean that the time spent would not count effectively against this sentence. It was said, and supported by letters from friends and family, that effectively he was a young man of good character, and that he was, as Mr. Singh has submitted to us today, somebody who was capable of change. Dealing with the overall position in respect of sentencing and in respect of both applicants, it was agreed in the court below that the starting point of 12 years was the correct position, as this was properly identified as a Category 1 offence under the guideline. That put this into a sentencing range spanning periods of 9 years up to 16 years. The learned judge found that these were life-changing injuries, that there was an association with gangs and gang violence, that each man in a different way had relevant criminal convictions, that the location of the event in a quiet residential street was an irrelevant factor, and that the combination of all of those features entitled and indeed impelled the judge to move the sentence up within the range towards the top of that range. So far as Mr. Romain is concerned, the learned judge looked at the nature of the offence, his antecedent history, the contents of the pre-sentence report, and from all that he had heard during the course of the trial about him. He found that there was a significant risk that he would pose to members of the public of causing serious harm in the future by the commission of further specified offences. The learned judge found him to be dangerous and therefore imposed an extended period of 3 years in addition to the custodial term of 15 years to be served. That sentence meant that the total term was 18 years, which included the concurrent terms for all the other offending and took those into regard in passing that total sentence. In Mr. Boykoff's case, the learned judge said that all that he had heard and said in regard to Mr. Romain applied also to Mr. Boykoff's, with the exception of his age. He had only been 17, albeit close to 18, at the time of the offending. The learned judge observed that he had relevant convictions for the joint drug dealing with Mr. Romaine, and that by the date of sentence, he had also been convicted of a serious assault, contrary to Section 20 of the Offences Against the Person Act 1861, using a car as a weapon in order to inflict harm. As in the case of Mr. Romaine, the learned judge found that all the criteria were met in Mr. Boykoff's case for passing an extended sentence, but taking account of his age and applying special consideration because of that, the learned judge did not propose to impose an extended sentence. He had, in the view of this court, quite properly found the applicant to be dangerous, but exercised his discretion and made due allowance for the fact that he was just under 18 at the time of the offence by adjusting the sentence accordingly and by not imposing an extended sentence. The total sentence in his case was, as we have said, 14 years. Submissions. In respect of Mr. Boykoff's, Mr. Singh submitted to us today and in writing that the sentence passed was manifestly excessive because the learned judge had, 1, wrongly increased the starting point due to the severity of the injury, 2, wrongly sentenced on the basis of gang membership, or more particularly, the level of his role and involvement within the gang, 3, failed to give proper credit for the fact that he had no previous convictions for violence or possessions of weapons, 4, most substantially, failed to give proper credit for the age of the applicant at the time of the offence. He also amplified his written submissions this morning by adding that this is a young man capable of change, and therefore the combination of those features renders this sentence arguably manifestly excessive. The learned single judge gave very detailed reasons for his refusal of leave, and we are, in some respects, simply echoing those reasons. This was manifestly Category 1 harm of the very severest type within that range. This was an injury that had a terrible and ongoing effect. The victim's right arm was almost severed. His injuries have been life-changing. His mobility and lifestyle are severely impaired. He suffers continuing severe pain. He has suffered serious psychological harm, including post-traumatic stress disorder and depression. He continues to need help with even such basic functions as washing and eating. He was, according to a psychiatric report available to the learned judge at the time of sentencing, somebody whose personality had been altered entirely by the events of that day. He remained at home. He had no social life. He was not communicating, even with his old friends. In addition, this was a joint attack in which Mr. Boykoff's had a leading role. He carried the weapon with him. It was carried in case there was a need to inflict violence, and he provided the weapon when he perceived that need to have arisen to the co-defendant, who was at that stage simply involved in a fist fight. The weapon was of its nature horrific. There was a higher culpability by virtue of the use of that sort of weapon, deliberately carried and designed to inflict serious injury. So far as the issue of gang association is concerned, the learned judge who heard the trial and all the evidence was best placed to make that assessment. And the submission on paper, albeit not pursued to the same extent before us today, that there was little or no evidence of gang membership was unrealistic. Where this applicant's precise role within the hierarchy of the gang falls cannot be determined by us. But it was clear, so far as the events of that day were concerned, that he did play a leading role in the commission of this offence. He was also involved in the fact that there was an attempt to conceal or dispose of the evidence by taking the weapon away from the scene. He stopping, even after the infliction of such a serious injury, to pick up the weapon, to wrap it in a shirt, and to seek to remove it. The starting point for an adult was 12 years, as we have said, within the range of 9 to 16 years. The matters identified, including the severe nature of the injuries, their consequences, amply justified a sentence at the very top of that sentencing range. That was the position before any account was given for the other offending. The learned judge, we are satisfied, rightly considered Mr. Boykoff's to be dangerous within the statutory definition and had considered the possibility of imposing an extended sentence. He chose instead, as an exercise of discretion, to impose a determinate sentence based solely on his consideration of the relevance of Mr. Boykoff's age at the time of the offending. It is right that Mr. Boykoff did not have a previous conviction or any previous convictions for violence at the time that this offence was committed, but that hardly mitigates the position when by the time of his conviction he had an offence for had a conviction for a Section 20 offence and had been convicted in the youth court of the joint dealing in Class A drugs with Mr. Romain. The learned judge gave careful consideration to his age, and indeed it was that deflected him from imposing an extended sentence. The result of that is that he will spend considerably less time in custody than might otherwise have been the position. The learned judge also had express regard to the other mitigation available to Mr. Boykoff. The sentence passed for the totality of the offending set against the background of the facts of this offence and his antecedent history was not arguably manifestly excessive. Turning to Mr. Romain's position, his application on the papers argues that the sentence passed was manifestly excessive on the basis that, notwithstanding the learned judge's finding of dangerousness, which should be noted is not challenged, the appropriate course was to impose a determinate sentence, and that in all the circumstances the length of the extended sentence passed was manifestly excessive. Again, the learned single judge gave very detailed reasons with which we agree. The learned judge considered very carefully the question of the imposition of an extended sentence. He expressly considered the alternative possibility of a substantial determinate sentence, but precluded that as not being appropriate in this case. It cannot properly be argued that such a decision was either wrong in principle or the result arguably manifestly excessive. The fact that Mr. Romain was a relatively young man does not mean that an extended sentence was an inappropriate penalty in all the circumstances. The learned judge was right to reach the conclusion he did, based, amongst other factors, on the recommendation of the pre-sentence report that the statutory criteria had been met. And the judge was right in his assessment of where this offence fell within the available range. He did not go to the top of the range, nor indeed did he go above it. But in passing a sentence of 15 years as the custodial element in this case, he took into account not only the offences related to the incident in June of 2017, namely the possession of the bladed article and the offence of violent disorder, but he also sentenced for offences of dealing in Class A and Class B drugs. For all those reasons, it cannot be reasonably arguable that the sentence passed in either case was manifestly excessive or wrong in principle. Accordingly, we refuse the renewed applications for leave and the application for the extension of time, which we make clear would have been granted had there been merit in the renewed applications for leave.
Thank you very much. Thank you very much indeed for your assistance, Mr. Singh. We're now going on to a non-counsel case. Don't feel you need to stay out of a sense of courtesy as far as the court's concerned. We are well used to addressing an empty courtroom. Thank you very much.
Thank you very much, my Lord.
The violent feud between the Kempston K-Block and Mile Road gangs in 2017 left a trail of destruction, fear, and serious injuries across Bedford. What began as a struggle to fill a power vacuum quickly spiraled into a series of calculated attacks involving knives, machetes and firearms. The swift and coordinated response from Bedfordshire Police, supported by compelling forensic evidence and surveillance, ultimately led to the significant prison sentences for key individuals at the heart of the conflict. The judge's words during sentencing made it clear. This kind of gang warfare, driven by drugs, ego and retaliation, represented one of the gravest threats to public safety. Now, with many of those involved behind bars, authorities hope this marks a turning point in restoring peace to the streets of Bedford, though the scars left by the summer of 2017 will not be easily forgotten.